Yes, madam. We'll start from here. Yes.
My lord, serial number 39, my lord. We applied some necessary document in this case, my lord. I am for the petitioner. My lord, kindly have it 2 weeks after, my lord.
39.
Yes, my lord.
Well, serial number. Serial number
weeks. It can go to 19th of September.
Please, my lord.
19th September. At the request of learned advocate. Miss, what is your name? Madam, what is your name?
Swati.
Swati.
Yes, my lord.
So and so, so and so. 10 to 19th of September. Yes.
Serial number 33, my lord. Mr. SN but is no more.
30.
Maybe adjourned.
30.
33.
33.
He
Yes.
appeared for A6.
33. So what do you want?
Adjourn. His colleague requested me to seek adjournment.
Adjournment. 20th September.
He is not. He is no more SN but is no. Yesterday has expired.
Who?
SN but advocate for accused number 6.
So we can keep little longer. Little longer we can keep.
I don't know. He asked me to seek adjournment for a week.
25th of September. Let us see.
My lord, one more request may I make, my lord. Serial number 60. My contempt I have filed first. Then they have filed writ appeal as a shield for contempt. May I take it 2:30 or contempt above any date?
We'll go, both will go to 26th of September.
In this case, the land is reserved for burial ground. An order to that effect is also passed by this honorable court in public interest litigation. In willful disobedience of that order, now they are constructing an overhead tank on that land.
13th. 13th.
Already late.
That is the reason we are, the urgency is that they are already constructing there.
Actually, you see this, yeah, our union on Mr. Kulle. I tried contacting Mr.
11th. 11th.
Not in this petition that is pending before the honorable court, there has been orders passed for institutionalization of the minor child alone. It's a visitation matter, and the child was admitted for 2 days and she suffered from dengue-like illness and urinary tract infection.
If you urgency, then 9th. Otherwise, 19th. Tomorrow not. 9th.
Not in.
Capital of the 807 matter.
Pardon?
807 recapital.
No, I
Four
will
matter.
permission.
So one respondent exhibiting the decree 1 in 2 days. So urgency is that it will be posted by 5th of September.
You filed interim application for posting earlier.
Not.
Number 30.
You file IA and we'll post it, prepone it. Yes, not
Number 30.
1 second, one by one. Yes, madam. Pardon, little louder.
From Monday.
Here, demolition. Monday? Monday.
Lord, serial number 30, my lords. It may kindly be listed along with writ appeal 952 of 2020.
330.
Which one?
Says it's between the same.
So
party.
30 as requested by learned advocate Miss so and so, so and so. It shall be listed with writ appeal number 952 of 24, 23. When it is coming up? On 21st October. On 21st October.
My lord, memo for.
Not writ appeal, not fresh matter. 5/8/2024, my lord, the government comes with a notification allotting the seats not for reservation rotation of the president and vice president to town municipal councils. Within span of 2 days, not a calendar of event came to be issued without any opportunity. Not we approached before the learned single judge, bringing to the notice of the court that the rule 13, not the policy of reservation rotation is not followed. It's in breach of that rule.
What do you want next?
No, the interim order is not granted. Not elections are on 6/9. May I pursue the lordship to take this matter tomorrow or day after tomorrow, my lords.
If the your urgency, then 9th or 10th, otherwise it will
But
go to
not by 6/9, my lords, if the notification is not stayed, then my lord, the election will ensue, my lords.
10th.
Not, the elections are on.
Memo for posting, my lord.
Elections are on 6/9.
Correction.
Elections will be held on 6/9, my lords. Then my petition will become impetuous. Elections are scheduled on 6/9.
On 6/9.
6/9.
6/9.
Yes, my lords.
So you are coming at the 11th hour.
Not, so the trial court, not, the single judge, not, didn't grant interim order, not, issued notice.
Judgment is available or not?
It's not.
Judgment is the next in the writ appeal.
No, no, my lords, it's only interim order. The court has. Single judge not issued only notice, didn't grant interim order.
Two more.
Please.
Serial number 13, my lord. Memo for post.
So, respect to this motion.
Serial number 13, my, I'm sorry, serial number 13, my lord, may I request for an adjournment, my lord? Personal inconvenience to senior, my lord, I
Serial number-
request for a week's time, my lord, in
13.
serial 13, my lord. I appear for the appellant in the first matter, my lord, there's a contempt petition.
Delay of 31 days.
Yes, my lord,
We issue notice. Notice returnable
Lord.
on 19th of September.
much.
My lord,
Serial
My
number
lord.
75, my lords. Serial number 75. This serial number.
Yes, one, yes, Mr. You want to mention? Yes.
and memo
Yes,
for posting, my lord.
My lords, on
Appellate.
19th of July, this honorable court allowed the writ petition in a medical education matter and directed for admission of the student petitioner in to the Karnataka Examination Authority. Despite my lord's orders, on 1/9, seat allotment is done, and I have not been allotted a seat, and from 19/7 till 30th, they have made me run around, not given me the link, and the seat is not allotted. Now, second round will be held on
So what do you want? Contempt is,
day after, contempt, my lords. Day after tomorrow, if we discuss. See, second round, if they allot the seats, then I'll be stranded again.
day after.
Please, my lord.
Yes, madam, you want to mention?
Serial number 49, your lordship.
40?
49. Your lordship, office objection has been raised regarding filing the clear and the office objection has been raised regarding filing of the clear and translated copy of the documents that we have filed in our counter affidavit. Kindly a week's time may be given to file the clear. and-
49 will be listed on 18th of September.
Much obliged.
Memo for posting, my lord.
Stand over to,
Appearing for appellant, my
one
lord.
second, in 49, stand over to 18th of September. As learned counsel, Miss so and so states that before the next date, the office objection regarding the translation will be removed by producing translation of the relevant document in the rejoinder affidavit. In the affidavit, just in the affidavit. Yes, Mr. You want to mention? Yes, yes. 51, it will go to 14th October.
For appellant, my lord, it's
40. 40, 40. 40 is what? Writ petition. What is the PIL?
My lord, the petitioner's counsel is there, sir, serial number 40.
What is it about?
My lord,
40, 40.
my lord. My lord, posting for memo, my lord, for the appellant.
What is the matter? You tell us.
well,
We are asking what is the subject matter, Mr.
my lord, providing of access to the public, my lord, main road. My lord, that road has been,
No urgency.
That's after taking the notice of this honorable court, the school is altered, dismantled, and he is making his house, there's some urgency. This is the school one, on the day I.
We'll see on 13th. On
He-
13th.
it's the altered. The school is dismantled, my lord.
13th.
My lord, for appellant, my lord, it's a
13th.
commercial suit.
Serial number 75, my lord.
75.
I appear for the appellant, my lord.
My lord, the appeal is preferred by the third party promoter of the petitioner company, my lords. The challenge is to the assignment debt by the secured lender to the asset recovery company. My lord, the urgency is that the matter regarding the same issue regarding between the same parties is before the NCLAT on Monday, my lord. I'm requesting that the matter be taken up at 2:30, my lord.
Monday.
No, today at 2:30, my lord.
What is that urgency?
My lord, the urgency is that one, the matter is before the NCLAT on Monday, and two, that we're challenging.
Before
the
NCLT,
NCLAT, NCLAT.
NCLAT.
NCLAT is on Monday, my lords, and the learned single judge in the writ petition has held that the writ is maintainable and refuses to adjudicate, saying let the NCLT adjudicate the issue, which is why I'm requesting it to be taken up at 2:30 today.
We'll list at 2:30, take up at 2:30. We'll see.
Please.
We'll see on at that time whether it is urgent or not.
I'm grateful.
Minute for appellants.
Yes, Mr. Yes,
My lord, I'm for appellant, my lord. It's a commercial shoot, my lord, wherein we are placed ex parte.
commercial matters are not to be mentioned.
My-
It is not in our roster.
For posting, my lord, for posting.
Posting, you go before the court concerned. Yes.
My lord, my serial number 17 to 20, kindly list after 1 week, my lord. My
Serial
senior is
number?
not feeling well.
Serial number?
17 to 20, 17,
17
18,
to
19,
20.
20.
What is that?
So this
17
matter,
to-
your lordship,
All
the
right.
learned AAG, we have complied with the order. We have filed the affidavit, your lordship.
Complied with,
Yes, your lordship. The learned AAG will appear, your lordship, in this.
complied with.
We
I,
have issued an appropriate endorsement.
I don't have instructions, my lord. Kindly list it.
What is the compliance?
The compliance is, it's a government lake, my lord. That lake land they have granted. We have given an endorsement that cannot be regularized, and it's a forest land now.
Tomorrow. Or let us see, you want time? 11th at 2:30.
Obliged.
Memo for posting, my lord. PIL, there was a preemptory order for compliance of office objection. PIL has been dismissed, my lord. I have filed application for recall, my lord. Recall and restoration.
19th.
Here it is, my lord. That is being finalized, my lord.
What is final?
Hello?
What is final? You don't remove office and then you plead urgency.
Paper copies took some time, my lord.
Then you should have done, if you had urgency, you should have done it.
From Karwar, I had to obtain the copies, my lord, which took some time, my lord.
17th. 17th.
Bill number 22, my lord. It was to be listed along with the writ appeal, my lord. I had not given the number. It is 652 of 24, my lord. Bill number 22, my lord.
To be listed with writ appeal number 622 of
652 of 24, my lord.
652 of 24. On which date?
Any date, your lord.
On 26th of September.
Lordship, PL number 21, my lord. I appear for the respondent.
Yes.
I filed the compliance affidavit, my lord. However, need a short accommodation. The organ council shall be
12th.
11th of
11th.
11th. Gratefully.
11/9. Yes.
My lords, a memo for posting for a fresh writ appeal, my lords. The learned single judge, my lords, has interfered with the recruitment process of Karnataka Power Corporation Limited, who I appear for. And my lord, the employee who had filed the writ petition has been placed, my lords, in seniority level above employees who are already promoted, my lords, to the post of assistant executive engineer. My lord, there is threats of contempt petitions being filed, my lords. I request for a listing next week, my lords.
It will be listed once you remove the office. Wait for a week.
Office objections are removed, my lord.
Then wait for a week. If it is not listed, then again mention. Yes, Mr. Yes, Mr. Council. Yes, start. Yes, madam.
72, my lord.
72, yes.
There's some urgency in the matter, my lord. My querying operation has been stayed by an order of the COP, Committee of Petition. If my lord may be pleased to take up at 2:30, my lord. Since last 14 days, I'm not carrying on operation of the mining and querying. At 2:30, my lord.
Is under office objection?
Yes, my lord.
There is one small office objection on legible copies. of
Ah,
the
it is
sketch.
under office objection.
My lord, only
The
small.
office objection shall be removed within 1 week, stand over to be listed on 17th.
2 days. I'll remove it in 2 days. my lord.
Within 2 days.
9,
To be listed on 17th.
please.
Same order. To be removed within 1 week. You may remove within 2 days, but we are granting 1 week. Yes.
List number 2, seal number 1. Ambrish, please.
So this,
Take notice, my lord. There's no urgency as such immediately. He asked for only for the second round. Second round will start after 12th only.
we'll see notice
Next week.
returnable on.
Eligible is time, my lord, but-
Second round is not going to start so soon.
So soon.
At least it will take,
Wednesday, so,
it will take 15 days
yeah, well, after 12th, my lord.
after 12.
Central counseling after getting over the central counseling.
So when shall we make it returnable?
Next week, next weekend, my lord, anytime.
13th or 17th?
Yes, 13th, 13th, your lordship.
13th, notice written on 13th, learned, who is accepting the notice?
I'll accept notice for my lord, R1.
Learned advocate, Mr. Ramesh accepts notice for respond number 1 from a learned additional, you are Mr. Hegde. Accepting notice
R2.
for R2. Only 2 respondents are there.
Yes, only two.
How many respondents?
List one. Cell number one.
Now, these are the election to which bank?
It is
Board
the
of-
DCC Bank, not Chitradurga District Central Cooperative Bank. There are totally 560 members.
So it is the bank, managing committee of the bank.
Yes, Vinod, it is the managing committee of the bank.
The process has started.
Yes, Vinod, the process is
Calendar
started.
of
4/9
events
is
have
the
been-
date.
Calendar of election is not on record.
It is on record, Vinod.
It is on record. Where is it?
Vinod, page 60, Vinod, in WP number 1324 of 24, it is at page 62.
Page 52,
62.
62.
At page 64 is the calendar.
That is not the notification under Rule 14. Returning officer now issued the calendar of events on 26/8.
Hmm.
The tallies with the
Pass off
same
this,
schedule.
my lord. This is the calendar of events. Process have been commenced. About 26 nomination papers have already been filed.
This will, which makes cooperative. Cooperative societies. Rules and act both.
In the groups.
So any provision for post-election remedy?
Beg your lordship.
There is a post-election remedy under section 70 subsection 2.
settlement of disputes, my lord, chapter 11(9).
So
See,
we will
Lords.
get to that remedy.
Lords, may I just say this, my lords?
In wake of the ongoing process.
Beg your lordship.
My lord
Hey.
has observed that in my lord's order, my lord.
May I just,
My lord, I'm
is-
sorry, my lord,
Gujarat judgment,
pardon me?
Gujarat judgment.
No, my lord had, no, my lord had passed this order on,
And this.
my lord, on 27 June 2024, in writ appeal 280 of 2024. My lord, paragraph 5.3 and 5.4.
And your, your debility under section 20 and read with rule.
my lords, my grievance is something
will
else.
Require a factual inquiry.
My lords, my grievance is something
No,
else.
lord, it has
I-
been provided. We will produce the materials.
Lords, my grievance is something else, my lords. That's not at all my grievance.
Yes.
Lords, my grievance is something else. It's not pertaining to any factual assertion, my lords. Kindly have a look at page 132. Just one fact which I will bring to your lordship's notice before I take your lordships to page number 132 is the committee elections were conducted on 25/2019 for a period of 5 years, which would expire on 25/2024.
25.
20th of May 2024, it will expire.
Committee.
Please, my lords. The term of the committee will be 5 years from 20th of May 2019, which will be essentially on 19th or 20th of May 2024, it will expire. Now, in respect of those societies whose term was due to expire during the period when the code of conduct was there, the government intervened and passed an order under section 121 of the Karnataka Cooperative Societies Act on 21/3/2024, which your lordships will find, my lords, at page number 132. The relevant portion is at page 134, clause 1. The elections of cooperative societies, cooperative banks, apex societies, whose term of office of the governing bodies will expire during March 24 to June 24 of the Karnataka Cooperative Societies section so and so, made an exception and postponed the elections of the governing body of the cooperative societies till 6/6/2024 and continued the tenure of the existing governing body and office bearers. Governing body should not take any important decisions during the extended term of the office and should be limited to operational activities to day-to-day activities. So the elections which were due to be held on or before 19th of May 2024 stood postponed to 6/6/2024. So this was the first step. Notice your lordships will find that at page 133, there is a reference to section 121 by the government. Notice I'll later take your lordships to section 121. Then on 5/6/24, lordships may kindly take page 139.
But your submissions outside the original prayer can't entertain. Original prayer in the writ petition is only in respect of the eligibility.
Then make this request, my lords.
The voters. Any further peripheral submission can't be entertained.
Can I make this request in that event, lords? Your lordships may permit me to withdraw this writ appeals with liberty to reapproach the learned single judge on any fresh grounds. I'm not rich. If your lordships are feeling, my lords, that I'm agitating something which is beyond the scope
of the hearing of the present writ appeal from a learned senior advocate, Mr. Ravi Kumar.
Ravi Shankar.
That much you pardon.
Let's.
Ravi Shankar seeks permission to withdraw the appeal, stating further that the appellant would opt to approach learned single judge by filing appropriate procedure. Full stop. Permission to withdraw is granted. However, this court does not express any opinion on merits in respect of any such recourse and the contentions which may be raised.
Please, my lords.
Disposed of accordingly.
Item 2 also.
2 also the same, my lords.
Same.
Please.
I'm appearing for the bank. I have no
Learned
objection.
senior advocate, Mr. So and so appearing for bank has no objection to the withdrawal of the.
Seal number 3, to Prithvi Shemke.
Sorry, we are dismissed. We have heard that the deputation and transfer both will be governed by the statutory timeline in the guideline. So it is dismissed. Yes. Is dismissed.
Dismissed. Mahesh, be there in the fifth matter.
This is seal number 4.
This challenge.
LM Chidanandaya.
Petition in the matter.
This is yesterday's matter? No.
Granted a license under Rule 3B of the Karnataka Minor Mineral Concession Rules. Rule 3B5 of Karnataka Minor Mineral Concession Rules. It's a special provision where I've been granted for construction of public roads and etc. There's a provision in the Rule 3B, your lordships, wherein it exempts me from paying the royalty. Rule 3B, subclause 5 of the Karnataka Minor Mineral Concession Rules, the provision to Rule 5 says that I am not entitled to pay royalty. After the work is done, your lordships, they have issued a demand notice at Annexure A, asking me of 24 crores, asking the royalty to be paid under section 190 of Karnataka Land Tenure. When I've been issued a license under Rule 3B of Karnataka Minor Mineral Concession Rules, section 190 of the Karnataka Land Tenure Act does not attach. And this is squarely covered by this honorable court's judgment and producing the copy of the judgment. For contractors, royalty is exempted under Rule 3B
5 of Karnataka Minor Mineral Concession Rules.
Are you not late in point of time?
No, Your Lordship. Notice issued to me on 19/12/2018. I have issued reply to them and the reply is given, the executive engineer issues the notice for recovery on only on 2010 to 2023.
Before annexure, any other order must have been passed.
2010, 2023, Your Lordships, the executive engineer files it. Your Lordships, this.
No,
matter
this,
was filed before Kalburgi bench, without knowing it's a
Where
single
is
bench
the,
matter.
where is the order whereby the amount was sought to be imposed?
Annexure A, Your Lordships.
That is the recovery as per the land revenue,
That's the order being passed, Your
as
Lordships.
arrears of land revenue.
As areas of land.
It must have preceded some other order of actual imposition or actual levy. This is an order whereby the authority says that recover the amount as arrears of land revenue.
Demand must have been.
So it must have preceded a order. So in that sense, you may be late. You find out.
Yeah.
Lordship, sir, it is not, demand notice is issued to me, Your Lordships, on 17/7/2023. That's
When?
annexure.
17/17/7. So you are late by 14 months. You did not do anything by 14.
Kalburgi bench thinking it's a single bench matter. The matter is transferred now to as it's a mines matter, we have to file before the bench, before the Bangalore bench.
But you are not challenged that 23 order.
Order is not challenged in 2023, Your Lordship. But this honorable court judgment is very clear, Your Lordships, that ILR 2010, Karnataka 711, Your Lordships, which says that royalty cannot be paid. Royalty need not be paid for construction activities when it is issued under Rule 3B of Karnataka Minor Mineral. May I read Rule 3B of Karnataka Minor Mineral Concession Rules, Your Lordship? It's a special provision. The rule itself exempts me, Your Lordships. I've given reply. Rule 3B, Your Lordships, may kindly look into of Karnataka Minor Mineral Concession Rules.
You are not a civil contractor.
I'm a civil contractor. I've been granted, Your Lordships. This is not, I'm not granted.
You are engaged in the removing building stone material from the private land.
To do public work only I've been given. It was issued under Rule 3B itself, Your Lordships. Under Rule 3B, I have been issued the license, Your Lordships. The work was granted in 2007, I've completed in 2013. The Deputy Director of Mines and Geology does not dispute till 2018, Your Lordships. 5 years delay from Director of Mines and Geology. There's 5 years delay from Director of Mines and Geology, not from my end, Your Lordships. Deputy Director as issued after 7 years, so not 7 years.
So what we were searching is found out by my brother, which is at page 77. And that demand notice is as back as of 2018.
Yes, Your Lordship. I've given my reply, Your Lordship.
18, 6 years you did not nothing. And when only they are seeking to recover areas of revenue.
The notice is issued very late to me. I've completed in 2013. The Director of Mines and Geology issues notice.
This
to me.
notice is at 19/12/2018, madam.
Yes, Your Lordships. I've completed work in 2013. 5
But
years
you-
delayed by the Director of Mines and Geology.
You never challenged this for 6 years.
I've given reply, Your Lordships. They have not considered my reply. This honorable court in the said judgment is very clear. And may I read Rule 3B, Your Lordships? I've been exempted under Rule 3B. I've been given license under Rule 3B, Your Lordships. Rule 3B may be kindly looked into. I request this honorable court to look Rule 3B of the Karnataka Minor Mineral Concession Rules. Because I've not produced the original lease deed, I've asked my client to get the lease deed copy, Your Lordship, so that I can produce to this honorable court to show that Rule 3B will be attractive.
You first have to come out from the aspect of delay. So what is the amount now you are seeking? 24 lakhs, 57,000. No, 20.
2 crores 45.
2 crores, your lordship.
2 crores 45 lakhs 7,070.
2 crores is the amount.
So you deposit at least half of the amount.
I'm requesting only rule 3B may be kindly looked into it.
We'll consider, but having regard to the very conspicuous aspect that you did not do anything since 2018. And now you are approaching the court when the notice to recover as arrears of revenue is issued. We may issue the notice in light of your contention and this reliance on this judgment, but you deposit the amount, at least 50%.
May I persuade your lordships to see Annexure K, your lordships. Annexure K, page 83. Translated is at 85. After my detailed reply, no opportunity of notice is given to me for hearing. On 5/7/2023, to my
That-
reply of 2018.
That is not the question. You said tight since 2018 in respect of demand
Your
notice.
lordships, the order has been passed on 5/7/2023, your lordships, Annexure K at page 85. The 2 crores 45 lakhs is issued in my reply, to my reply at Annexure
So
K.
what is page 77 then?
Yes, that
It is show cause notice or order?
show cause notice, your lordships, calling me to give reply. I have given reply, your lordships. I have given detailed reply. Only in 2023, they act upon to my reply.
So read the last paragraph. It is a demand. It is in Kannada.
Yes, your lordships.
Yes. Is there translation is there? So in that notice itself, it was stated to you that unless you pay, it will be treated as land revenue, arrears of land revenue. So you did not do anything.
Given reply, your lordships. Annexure
No,
K,
reply is
page-
not the question.
Immediately Annexure J, page 80, I have given your reply, your lordships. And when license is granted under rule 3B, your lordships, the royalty is paid, deducted and then given to me to the running account bills. For that reason only at Annexure N series, at N series are the running account bills where my royalty is deducted and given to me, your lordships. I produce all these documents, not considered by the Director of Mines and Geology, your lordships. Deputy Director of Mines and Geology. As per the judgment which I have given, once a civil contractor is given for a work, it will be cut in their running account bill itself, your lordship.
So you deposit 1 crore of rupees, 50%.
In the year 2007, the matter has been taken. 2013, the lease is expired and have been finished the work in the year 2013 itself, your lordships. Now they are imposed in 2023. Lordships, kindly have it tomorrow, your lordships, or Monday. I'll seek instructions from the kingdom and just make submission.
Tomorrow.
My lord, may I make one submission, my lord? My lord, the amount is 24,57,000, my lord, not 2 crores.
Not 2 crores.
No, my
So
lord,
that is what I
24
read
lakhs,
earlier.
57,000.
Somewhere it was,
My lord, that is mentioned, but.
then you can deposit, madam.
So I will seek instructions and make support.
24 lakhs you have to deposit.
Lordships, that's for the
Thank-
for the work which is conducted in the year 2007, your lordships, I've been.
Thanks to your learned friend, you will have to deposit less, 24 lakhs.
Even 24 lakhs is not, you also.
It is the cost of your delay, nothing else. That is what. Take instructions tomorrow.
But before that, I will just only say rule 3B.
If you want more time, then we'll keep it next week.
No, rule 3B may be kindly only looked into before any passing order, because rule 3B is fairly covered to me, your lordship. That's the reason.
Only after seeing the color of money we'll look at it. Tomorrow or 12th, when?
Tomorrow, your lordships.
Tomorrow.
otherwise it will be called on 12th itself.
Pardon?
12th itself.
12.
Number
12th at 2:30. 2:30. At the stand out to 12th of September at 2:30 at the request of learned advocate.
Number 5. Mr. D. Nagaraj.
Give me, I don't have copy.
Using scrap.
I help you and you take away my file.
Produce lot tire, iron, soil. Utilize that rock
Okay, then,
for- Thereby, Lord, he is contributing to the environment
You have this, I'll take the connected one.
protection. May I request, Lord, the process involved, will I just take, Lord, page number 210. 210 or 209. The process involved in the time. No, the closure order has been issued in the month of August 2023. It was kept in abeyance for some time. Thereafter, the abeyance order has been withdrawn. Thereby, my lord, we have been prevented from operating without notice, my lord, without following the procedure under law.
Notice returnable on 26th of September.
That's
Update, my lord, about 1,000 in kind
may
appreciation.
permit to accept notice.
Learned advocate Mr. Mahesh
Here,
Sudri
where
for
without-
the respondent state pollution control board will accept notice.
1,500% are without liability. Short date, I will request, my lord, otherwise, my lord, they without work.
We have different definition of short date. If you want to apply, we'll give.
My submission, my lord, kindly.
Hmm.
Short date.
We have a different definition about short date.
Lord, then I request, my lord, to have it next week.
You want short date?
Otherwise, my lord.
Short date, all that. Notice returnable on 16th October. That is our definition. When the request for short date comes.
Industries are not operating, existing industries, not there. Not any date, as my lord. Not there are 5.
That's I accept notice for respondent number 2, man.
Respondent to all.
My lord, I take notice for 1 and 6, my lord.
Whereas learned additional government advocate Srimati Neelofar Akbar, 70,
71, and not 101.
101.
Here,
70,
same.
7071 and 101.
Yes.
So same order.
same. Sir, one more matter may be connected, my lord.
70. So you are not giving hearing to them while closing down.
No, no notice.
That's if I can just show it as point out. Anyways, my lord,
Right.
we should
Earlier,
notice.
the
I'll come
price
back.
was like earlier, they issued similar order. When we challenge, my lord, that the same was treated as the notice thereafter we have given up.
Yes, yes.
Similar order could be passed, my lord. Because law mandates, my lord, before issuing notice, before issuing closure direction, they have a rules, my lord, which provides for issuing notice of proposed direction. And which says, my lord, they should give me time for some time. They
Let's
should
let me
specify the
check. If
action to
that's
be
the
taken.
case, my lords, I will make it myself.
Lord, quoted the rules also. They should specify what action I need to take. They should specify time limit. Without which, my lord, all of a sudden they are closing, my lord, a existing industry.
So they have got battery of lawyers in terms of Mr. Chaudhary and Ms. Vaishnav. So both will take instructions.
One more matter not listed today, my lord, just give number. One more industry, one more case not listed today, I give number.
Tomorrow?
I give number, they be called together, same day.
Today not possible. Tomorrow or 11th, whenever you want.
Yes.
Tomorrow. List it tomorrow.
All the matters.
6, 7.
677, 67, 567, 70, 71, or not, all are.
Yes, all will be. In all same order. There are office objects in those matters.
All matters.
So you remove before the next. In 70, 70, 70, 71 and 101. Add a line that office objections, whichever are left out, comma shall be removed before the next.
It's 8.
Right.
Pradeep Naik.
This is the application.
Series of directions that have been passed by the Honorable Court.
Because the urgency which I had pointed out yesterday, my lord, was the application filed by Bangalore Metro.
You filed application?
We have filed an application, my lord, on behalf of Bangalore Metro Rail Corporation for permission of the court, my lord, to fell some trees. There is a process that the court has determined we must follow. It's IA number 6, my lord. 6th August 24. I think, my lord, there's no objection from any party now.
What is that? Who are you? Metro?
Bangalore Metro, my lord.
Bangalore Metro?
Respond number 5.
RCL is what?
I beg your pardon, my lord?
Full
BMRCL, Bangalore Metro Rail Corporation Limited.
Rail Corporation.
This, my lord, has gone through a process of the tree expert committee.
So what is this order at page, reproduced page 3 of the tree officer? What is that order?
That's
Lord,
the-
in my case, that order is still, Lord. I am appearing for PRI, which is another, my lord, joint venture, rail project of, my lord, the
No, which-
state and
Mr.
central.
Chinnappa, what is this order? It is in favor, it permits you to,
You know, my lord, the IA number 6, your lordships have. One
My
second.
eyes are.
no, no,
Your.
your matter.
My application, my lord, is for an application for permission.
Correct.
The tree officer has granted me permission,
Granted
granted permission.
by this order 20th/7/24.
Yes, ma'am, by 27/24. That is pursuant, my lord, to a tree expert committee, which has been appointed by this court, having verified every single tree, checked as to whether it can be retained
Committee was appointed by this.
by this court. One second, this one.
Committee consisting of?
Consider 3 officers, my lord. And a government order was then issued appointing them. Because what happened, my lord, is initially the Preservation of Trees Act, under the Karnataka Preservation of Trees Act, there's a tree officer. To assist the tree officer, my lord, a technical expert committee was appointed, which now gives a report, and on that basis, the tree officer issues the order in the form of an official memorandum.
We grant permission.
Well, it's-
Tree officer has verified, committee has
Please,
recommended.
so far as BMRCL is concerned, I have not filed objections to this application. They are required to file an application and for every tree that they cut, which they have done. It shows the application of mind and they have followed the directions of this honorable court. I have only one submission to make, that throughout this honorable court has, one of the conditions imposed is that there must be compensatory afforestation. For every tree they cut, they have to plant 10 trees. But they also have to conduct quarterly reports, and they have to upload reports every 3 months to inform the honorable court and the petitioner specifically of the condition of those trees. They have not provided quarterly reports for 1 year now. So my only request is that they may be directed to update the quarterly reports with immediate effect.
We'll do that.
Because the compensatory plantation is done as a condition of felling 1 tree. If those trees are not maintained, then the entire purpose of the directions passed by this honorable court would be defeated.
If there are any reports outstanding, my lord, we'll file those. There's
For
no-
1 year, no reports have been filed.
Under, beg your pardon? No? Actually, my lord, under the act is 1:1. 1:1, but the court directed us to plant 1:10. Directed. There are earlier directions. Large number of orders. We are complying with those. We're complying with those.
They
My
have
learned friend's
accepted that.
complaint is that report has not been filed showing compliance. Those reports I'll file. No, but wherever, even in this case, now we've identified spots because there are two parts. One is translocation, because now we have to remove some and put them. Therefore, we identified spaces. But wherever there's no place, now we go to the closest place possible and then transplant them. There is a similar order, my lord, your lordships have passed on 12/6/24. 12/6/2024, your lordships have passed an order allowing, my lord, similar application filed by us. Same order of opinion. 12/6/24. Replicate. I number 6.
Minutes. Minutes. Pradeep Nayak. Minutes. Nayak, N-A-Y-A, Nayak. Minutes.
Office memorandum, official memorandum. Official.
My lord, just one submission.
Would your lordships also direct them to file the updated quarterly reports of all trees that they have planted till date?
My lord, just one.
Updated quarterly reports in compliance of orders of this honorable court of 25th March. Quarterly reports means of compensatory plantation and translocated trees.
My lord, and let them file it. My lord,
In
just
my
one
case, my
submission.
lord,
Yes,
No.
we'll file those. No.
government or copy ಕೊಟ್ಟಿಲ್ಲ ಅನ್ಕೊಂಡು.
Deeply obliged.
My lord, just one submission, along with the tree authority, if they can submit their reports about the translocation and the plantation of trees to the tree expert committee, that would help matters, my lord, because they are the expert committee constituted specifically to look.
No, no. Pre-expert committee's role, my lord, ends after the report is given. After that, everything is to the court.
My lords, I appear for my lord applicants counsel in IA number 485. Similar my lord order are passed by the officer and my lord similar exercise has been taken by the expert committee in case of my lord another my lord rail project called.
Yeah, right.
My lord, I am proposed respondent. What has happened is, my lord, on 29/5/2000. No, we have, my lord, the application may be allowed. What has happened is this, on 12/6/2024, my lord, the petitioner has obtained an order at the hands of your lordship, my lord, not to implement the OM dated 29/5/2024 without making us a party. That has, my lord, my lord, I am, my lord, Rail Infrastructure Development Company, Karnataka. It is a joint venture, my lord, of the state and central government. And my lord, we are, my lord, implementing agency for this Bangalore suburban rail projects. And my lord, we have undertaken, or there are 4 projects, my lord, to be undertaken. The present, my lord, OM is issued, my lord, in respect. I'm sorry. IA number 4, my lords.
IA number 4 is the impleading application.
ಅದೇ 4 ಅದು. Impleading application. ಅದೇ ಇದು vacating stage. ಇದಲ್ಲ. ಅದರಲ್ಲೇ ಅದರಲ್ಲೇ ಇದೆ. Last eಲ್ಲಿವರೆಗೂ. ಇದರಲ್ಲಿ ತೋರಿಸ್ಬೇಕಾ ಇದರಲ್ಲಿ ತೋರಿಸ್ಬೇಕು. R10, it will be R10. Lord, I have also filed one application seeking permission to implement, my lord, the OM issued in our favor on 29/5/2024. My lord, my lord, there is great urgency for this reason. My lord, we are incurring, my lord, 8 lakh rupees, my lord, loss every day on account of the, my lord, stay order that has been obtained by the petitioners. Yes, application is there. IA number, my lord, 5 is the application. And my lord, all procedures have been followed in our case also, my lord. And TEC report, based on the TEC report only, my lord, my lord, there is great urgency, my lord. Can I, my lord, appraise your losses that, my lord, every day, my lord, we are incurring. My lord, every procedure is followed, my lord. Similar to, my lord, BMRCL, TEC is the same. And my lord, the my lord, there is urgency, my lord. We are, my lord, your lordship's order is passed on 12/6, my lord, staying the almost 3 months by now, my lord. And kindly appreciate, the project is held up, my lord. It's a suburban project, and my lord, all clearances have been obtained, my lord. So lordship may kindly consider, my lord, having it, my lord, tomorrow or, my lord, day after tomorrow. At least, my lord. My lord, they have filed objection. Lord, 13. No, they did not make us party, my lord. They obtained an interim order against us without making, my lord.
Did not reach.
Two times, my lord, the matter was listed, my lord. It has not reached, my lord. That's the problem. Lord. This, my lord, IA was filed on, no, 5th August, my lord. 5th August it was filed, and, my lord.
The order was passed on 12th of June.
It was listed 2 times.
Order was
and, my lord,
passed
I,
on
in fact,
12th of June.
Made a request to lordships to, my lord, have it, my lord. It was in fact last week or 10 days back it was listed. 27th it was listed, my lord. It did not reach.
As any date, if
That
it
is
could
how,
be
my
at
lord,
2:30, I'll take the honorable court through. I filed a convenience compilation of all the orders that of which they were not in
everything is,
compliance.
my lord,
I'll
on
take the
par
honorable
with
court through that.
impartial. Everything, my lord,
Any day
we
at
have
2:30
complied.
minutes.
TEC has, my lord, conducted, my lord, local inspection. It has given its report, and, my lord, we have given, my lord, the locations for translocation of, my lord, the trees. Some early date I am requesting.
12 minutes.
Please, can it be at 2:30, madam? Please, please.
Grateful minutes.
Number 9. B. Vachan. Sumo PI.
This is a suo motu PIL, my lords, regarding the shortage of medical personnel in the state of Karnataka. The state has filed its objections on the last date, my lords.
My lord, I appear for respondent number 1, Union of India, my lord. My lord, my humble submission is that, my lords, this is a matter that concerns only the state. The state, health, your lordships are aware, is a state subject. We have released the funds to the state. Now the prayer is to fill up the sanction post for medical personnel in Karnataka state. Pardon? No, I have not filed any.
My lord, I have filed a report, my lord. My statement of objections I filed on 30th July 2024. Yes, my lord, medical personnel in the state of Karnataka. My lord, we have filled up, my lord, and as and when, my lord, the vacancies arise, my lord, we will take steps and we will fill up those vacancies. My lord, in case the amicus files any lapses, my lord, on our part, my lord, if it is brought to our notice,
My lord,
my lord, internal page 3 of my statement of objections. Two gives the, my lord, the column with regard to, my lord, the post, the number which is sanctioned, working, then the, my lord, as and when, my lord, the vacancies arise, then we notify and then we fill up the vacant posts. And my lord? Yes, my lord, that I have explained in paragraph 1. My lord, that I have explained in the paragraph. My lord, I've explained. My lord, I've explained that in the paragraphs, my lord, as and when vacancies arise, we are filling it up. Yeah. Vacancies, as and when the vacancies come, my lord, we are filling it up. My lord, paragraph 14, the last sentence. Yes, page 9. The last sentence, the vacant posts as on date shall be filled as and when approvals for filling up are accorded either through direct recruit mode or contract or outsourcing mode. My lord, and I have in the next paragraph also stated. 1 minute.
Now, according to their own tabular column at page number 2, it sets out the number of vacancies that are there in the medical personnel in the state of Karnataka. Now, my lords, what the state government, in my humble submission, needs to do is, my lords, apprise this honorable court of the steps taken by them to fill up these vacancies.
My lord, please take in page 3, my lord, the first paragraph. My lord, I'll just read to my lord. My lord, as to how with regard to, my lord, the sanction posts and those that are vacant, how we are going about doing it, my lord. Page 3, first paragraph, if my lord could. Yes. May I read, my lord? Paragraph 2 and paragraph 3. No, my lord, depending upon the urgency and the vacancies, my lord, that is there. And I've explained it till, my lord, paragraph 7. My lord, many of the posts that are vacant, my lord, they are in the process of being filled up. In each paragraph, I have explained, my lord.
May I make a submission, my lord? The learned amicus Shri Sridhar Prabhu sir appears in the matter. If your lordships would have it next week, learned amicus may kind of assist your lordships in some way.
My lords, I appear for the amicus on behalf of the amicus, Mr. Sridhar Prabhu. So he has instructed me that time may be sought to file a detailed response after studying the objections filed by the respondents.
My lord, I have met their contentions, and wherever there are vacancies, the process is on to fill them up.
The amicus is only, the amicus is to assist your lordships. I don't think he can make it an adversarial litigation. Kindly see the prayer it is to fill the vacant post. The state is in the process of doing that, my lord. In my humble submission, nothing remains for the amicus to say unless he can't file objections to what the state has to say. He can only place his suggestions for your lordship's kind consideration, which he has not done till today. And even otherwise, my lord, the scope of the
Very well.
Please.
my lord, your lordship may say that
Chinmay. My lords, I just enrolled myself in the bar. I just enrolled myself in the bar. I just enrolled in the bar, my lords. I'm not. Chinmay. Chinmay. Chinmay Kurandwad. Please. Chinmay Kurandwad.
My humble submission is respondent number 1 is not talking about. Very well.
Please.
This is number 10. Appear for the Milord. State. Respondent in writ appeal number 91. Lordship heard Milord matter on sometime in the last occasion. No, Milord. But matter is pertains to only this, Your Lordship, page 80. This is the cabinet, Milord, meetings wherein government took a policy decision, page 80.
Lords, may I start?
Milord, lifting the economy major.
It's a state appeal, Lords.
In the meetings held by the cabinet, my lord, the government took a policy decision to admit the appointment of 1,100 non-teaching staff for granting aid. Lord, under this scheme, my lord, everybody has been granted a facility and their appointment has been admitted granting aid except the petitioner. So, my lord, his case was considered on 22/11/2004. Writ petition filed to, my lord, give a grant with effect from the date of this government cabinet decision, policy decision dated 9/6/99. That has been allowed by the, my lord, learned Singh in the originally in the appeal. Then that order was sought to be recorded in the review. Subsequently, writ petition was allowed. And except the petitioner, everyone has been granted the facility with effect from the this government order issued in the name of the governor. It's a cabinet decision, my lord.
Lords.
Page 100 is the order passed by the Supreme Court, where, my lord, I have been denied benefits with effect from 9/6/1999. Under this order, my lord, the Supreme Court strictly directed that it is due to the inadvertence of the authorities that these three petitions have not been extended benefit with effect from 9/6/1999. Immediately after this order, petition number 1 and 2 has been extended benefit by the government. Benefit is only to admit the appointment to salary grant. My lord, release the salary. From, my lord, the order is passed with effect from. That's all, my lord. Salary has been granted. Your lordship may kindly, salary has been granted with effect from 22/11/2004. Lord, in the order dated 22/11/2004, the very commissioner himself says this benefit is granted by virtue of the government order dated 9/6/1999, which is a cabinet decision taken by the government. Order is issued in the name of the governor. The appellants cannot deprive me of this order, my lord, because this is a cabinet decision, it's a policy decision. The appellants who are before this court cannot take away my right to get the benefits. Now, once the government takes a policy decision, and in the order at page 94, the commissioner himself stated the benefits of grant has been given by virtue of the order, the government order dated 9/6/1999. Only because of this 9/6/1999 only have been given grant. Not only mistake committed by the commissioner is he passed an order on 22/11/2004, and at page number 96, he says that the 95, sorry, my lord, he says that grant will be given with effect from 22/11/2004. I sought for benefit of grant with effect from 9/6/1999. That has denied. I filed a writ petition. This honorable court allowed my writ petition. Now, 3 petitioners approached this honorable court. For the moment, may kindly see page 100. Lord, immediately after this order, petition number 1 and 2 has been extended benefits, and they have been given benefits with effect from 9/6/1999, except the petition number 3 is the respondent before this court. Lord, 2009, the petition 1 and 2 has been given benefits with effect from 9/6/1999. I am litigating from 2008 to till, my lord, 2023. My lord, learned single judge allowed my appeal is allowed by the government. Thereafter, (22/11/2004). That's all. My lord, what happened is I was eligible for grant as on 9/6/1999. My lord, authorities have not considered my case for admitting grantee need from 9/6/1999. They have left out my names of 3 petitioners on the list. That's why, my lord, we requested the government to 89, my lords. 89, my lord. Now, 27/5/1989. It is authorities who have not considered my case. Not only me, my lord, 3 petitioners. 3 petitioners, page 100 may kindly be seen. There is a clear observation by this court.
Let's stay.
Pardon.
Is not. No.
It is a question of eligibility for a grant with effect from 9/6/1999.
May I just clarify?
My lord, the importance of period, I will get the salary with effect from 9/6/1999. My lord, order is passed at page number 95 by the respondent with effect from the 22/11/2004. Annexure C1, page 94, my lords. This is the order under which my salary was granted. May I read, my lord? The order of this honorable order passed by the commissioner. My lord, page 95, dated 22/11/2004. Therefore, as explained therein, the proposal, the permission has been granted to these 9 non-teaching staffs for granting of the grant in aid under circumstances following conditions thereon. Condition number 2, the said posts are eligible for receiving the grant only from the date of the issuance of this order only. So 2004, my lord, my salary has been given to me. My appointment has been to salary. Pardon?
What happened?
Yes, my lord. 2 petitions have been given benefits.
Court set aside the endorsement, redirected, directed us to consider whether he's entitled or not. As per rules, he is not entitled.
Yes.
My lords, 2 of them, my lords, it was not, 2 of them, my lords, what had happened, it was a separate division. So by oversight, my lords, benefit was granted to them. Now we have withdrawn that benefit, my lords, after filing of this appeal. Now, my lords, kindly note one fact. My lords, as per rules, he is not entitled. He is now, my lords, a superannuated employee. He was appointed in a private management in the year 89. It is a private aided institution. My lords, thereafter, my lords, they will seek for salary grants, my lords, from the government. He is being paid, my lords, by the private department. 2004, he is admitted to salary grant. His order says he is admitted to salary grant from that day. Rule says that any time period before the salary grant period shall not be admissible for the purpose of government paying the salary grant. Management will pay it. From 2004, he has taken the salary, he has superannuated also. Now, my lords, one fact, my lords, is this, that I issued an endorsement, my lords, based on page 100 order, my lords, passed by this honorable court. Thereafter, my lords, he filed a revision, he filed an appeal. Appeal was dismissed. Then he filed a second appeal, which was again dismissed. Then he filed a revision, my lords, before the government, which was allowed. 1 second. Then he filed a revision before the government, which was allowed. Then in the review petition, my lords, government set aside that order again. Then, my lords, he approaches this honorable court. That order is set aside, again reconsidered, again sent for remand. Then, my lords, again it has been rejected. Finally, my lords, there has been no adjudication. Only on the ground of parity has been given. Now, my lords, parity ground, my lords, is not available in my respectful submission because we have taken back the benefit which was given.
Kindly see the order produced before this court. They themselves stated the benefits, it should not be page number 25, which is.
My submission, sir. 1 second.
Why they should make false submission? Page number 25, which is. No, kindly page number 25 memo file before this court may kindly see for the moment which is submitted now. They themselves stated that the order for refixation of pay and it is hereby ordered not to recover the additional given amount from the concerned employees. They themselves stated page number 25 may kindly be seen. The benefits which is extended are ordered not to be recovered from the petition number 1 and 2 in the writ petition. Kindly see, why should they make a false submission? Even in respect of these two. No. In the memo, they have stated, my lord, it is withdrawn. But the order says page 25, kindly for the moment, page 25, which is a memo filed before this court. They themselves state that the benefits will not be recovered at all. Benefits will not be recovered at all. Memo files stating that the benefits withdrawn. But order is something else. It is inconsequential. For the moment, may kindly see page 25 of the memo, which is filed before this court, my lord. In the last line of the order, my lord, the memo itself says that the benefits which is granted should not be recovered. So even today, my lord, those benefits not recovered.
My lords, as per rules, he is not entitled. Till date, there has been no adjudication, my lords, by any competent authority that is entitled to. I will be able to show, my lords, even from the page 100 order, all that the court said was reconsider. Thereafter, I have reconsidered and rejected. Then this honorable court directed, my lords, again for us to reconsider. And the only ground on the basis of which learned single judge allows is on the ground of parity. And that, my lords, the basis of that has been taken away because by oversight, my lords, it was granted to them. Negative equality, my lords, cannot be urged.
Lord, in the order which is.
And with all due respect, my lord.
Memo which is filed, now kindly see the heading of the memo. Here it is said, Lord, that the benefits has been withdrawn in the memo. But the order says the benefits should not be withdrawn. In the order produced by themselves, page 25, they said it is ordered for refixation of pay and it is hereby ordered not to recover the additional given amount from the concerned employee until further orders. They themselves says that the benefits which has been extended to petition number 1 and 2 in the order passed in the year 2008 should not be recovered. They themselves have stated, page 25.
Order, page 24 is what
memo is misleading. Memo, they says it is withdrawn. Order says it is not withdrawn. It should not be recovered. That itself shows.
My lords, may kindly see page 24, operative portion may kindly be seen.
They cannot recover the amount once it is given. It is settled portion of law laid down by the Supreme Court, my lord. Rightly or wrongly, if the amount has been given, the salary cannot be recovered. But it is not the only question, ground of parity. But it is the issue of eligibility. When I was eligible from 9/6/1990 and therefore I am entitled. It is not only the ground of parity, it is ground of eligibility. It is a scheme formulated by the cabinet. Therefore, I am eligible as on 9/6/1999. When everybody is entitled, everybody is being granted benefit, the petitioner was deprived of this benefits from 2008 to 2024.
He should be eligible as per rules. Kindly see the rule for a moment.
Writ petition was allowed. Appeal was allowed. In the appeal, please, please, my lord, translated copy of 179 minutes. Lord, in the appeal, this the authority clearly, my lord, directed me to direct the authorities to release the benefits. I will read the operative portion, my lord. Order, page 190. May I read, my lord? Appeal filed by the appellant under 130 education is allowed. Response 1 is appeal in the past or dated is cancelled. The Commissioner Depart Public Instruction Gulbarga as per judgment of the Honorable High Court of Karnataka dated 9/7/2008, already 2 persons from 9/6/99 to 2011 salary grant release being done. Respondent with regard to the appellant Syed Mansoor Kader, FDA with retrospective effect from 9/6/99, it is hereby ordered to consider the appointment as with the salary grant, and it is ordered to release the salary grant for the period from 9/6/1999 to 2011-4. In excess the power conferred under so and so. This order is passed. Appeal is filed. Appeal order is passed.
This order was set aside, my lord. This order was set aside.
No, this
At page
order was
number- at
this
page
order
11.
was sought to be my lord, sought to be reviewed by the very government.
Please.
What?
30.
Please.
Just kindly, serial number 15, I have some difficulty in the half.
Well, then may I make a request? My serial number 15 is of some urgency because there is a recruitment process ongoing. Serial number 15. So the shortest possible date, if it could be given, Malas, that because there's a recruitment process ongoing. Your lordships heard me about 2 weeks ago regarding an examination for the Karnataka Power Corporation Limited. Any date? Sorry, ma'am. May not take too much time. It's a very short, narrow compass.
Melody, can I request for week
15 and 66. Oblige.
If I may request for 17th or 18th. I have some difficulty on 12th minutes. Well, I'll be there 12th.
Then
So I'll-
Minutes, serial number 29 minutes, if it is not, if it is difficult for my lords today.
Serial number 12, my lord. Notice may be order delay is there, my lord. Delay is there, my lord. Notice may be order 165 day delay is there. Serial number 12.
Serial number 11 also, man.
ಯಾವ್ದು ಕೇಸ್ ತಗೊಳಲ್ಲ ಜಾಫರ್ ಯಾವ್ದು ತಗೊಳಲ್ಲ
Lord, kind leave, my lord. Serial number 54, my lord. The matter is pertaining to contempt matter, my lord. The learned single judge, by order dated 5th July, my lord, passed the order for pipeline connection to the canteen, my lord.
Which one? 54.
54.
Oh.
The learned single judge, by order dated 5th June 2024, direct the municipal commissioner to reconnect the pipeline connection, my lord, to the main chamber of the Udupi municipality. After that, my lord, they have filed review. That is also dismissed. And my lord, then I filed contempt before this honorable court. My lord, even though, my lord, after dismissal of the review petition, my lord, they are even after lapse of 90 days, they are not ready to, my lord, reconnect the, my lord, the pipeline connection. From last 6 months, my lord, my can't.
So what do you want? Time?
Yeah, no, my lord. The day after tomorrow, urgency is there, my lord. 6 months, my lord, I have closed my client in, my lord.
Day after tomorrow.
Yes, my lord.
Request of learned advocate.
2:30, my lord.
For the, that we can.
Please,
They decide.
please, my lord.
At the request of learn. You are for complainant. At the request of learned complainant, Mr. Pawan Chandra Shetty, 10 over to 5th.
Your Lord, Seal number 27, Your Lordship, 27. Hearing an IA. In the matter pertaining to redevelopment of Gandhi Bazaar Main Road. In that, I filed an impeding application, IA number 2 of 24, by impeding the Joint Commissioner of Police Traffic. So that application, the government advocate may kindly take notice and provide regarding the traffic, because a fire engine cannot enter that road and also ambulance cannot pass through that. Because now they reduce the width of the road to about 7 meters. That is about 20 feet. It was around 45 feet. The statement of objection also has been filed by the post respondent government, Your Lordship.
So what do you want?
So the impeding application, let the government advocate may kindly take notice and response is given to my application. Joint Commissioner of Police Traffic, they are the best person to say on that.
My lord may hear, my lord may hear this matter, my lord, step by step, they are getting respondents impleaded. I don't think the Joint Commissioner of Police is required in this matter.
What
My
it
lord
is?
may hear this, my lord, it is with.
IA for impleading whom?
IA 2 of 24 for making Joint Commissioner of Police Traffic. Because they are the necessary party to say that whether that road width, which is because there is no parking, photographs are produced. It is total mess, Your Lordship, during festivals and other days, impossible to move around also.
You are for.
So let the Joint Commissioner response, I want, that's all, Your Lord. So based on that, the petition itself can be disposed of. Because we are not experts, Your Lordship. IA 2, Your Lord.
Lord, for that, the writ petition has to be amended. How what relief he's seeking against the Joint Commissioner of Police? My lord, just impeding him and saying that, my lord.
Lordship, it is under section 215 of the BBMP Act, read with section 16 of the Karnataka Police Act. The suggestion has to be taken by the BBMP with the traffic police regarding the movement of vehicles. So that is not done. Your RTA reply, I enclose it, it is not done. That's why they are the necessary party to say that how the traffic can be handled if the entire road is open. Now till the road is not open fully, Your Lordship, not inaugurated. So that may, so that the problem can be solved, because there are 3 deaths have taken place in the 6 months ambulance. So let them respond to the IA.
When shall we take up?
IA 2 of 24.
Petition will be taken up when?
IA number 2 of 24.
Main petition will be taken up when?
Joint Commissioner of Police Traffic.
Main petition will be taken up on which date?
Pardon?
You want the main you are also petitioner?
Yes, sir.
So when will proceed with the main petition?
It was filed.
Tell your date.
Because now I have filed this application. After filing this,
we are asking that since you are for the original petitioner, when you will proceed with the main petition, except today?
Yes, sir.
When you will proceed?
We are for the residents of that. No, Your Lordship kindly fix any convenient date to hear because this matter was heard earlier also. And then after hearing the earlier petitioner, Your Lordship, the Joint Commissioner also may be point because the court is of the view that engineers have committed the mistake, BB engineers. Earlier it was the width of the, so I am only thinking that I have also given my plan. This court wanted a plan how it can be designed. So I have given the plan also sketch prepared. So that any date it can be, so that response come from Joint Commissioner of Police so that my petition can be solved basically.
We are on the main petition, Mr. Counsel. When you are going to proceed with the main petition?
Any date, Your Lordship, convenient.
Tell the date.
Next week, any date, Your Lordship.
Next week, 19th of September. All IS will be listed together. Yes, next.
2:30, Your Lordship.
Seal number
Any
20.
convenient date, 2:30.
No 2:30. As and when reaches.
Seal number 29, my lords. I appear for appellant.
Yes, Mr.
State is a contesting respondent.
One.
Seal number 29, 29.
Go on.
Minutes an adjournment minutes, any short date minutes.
Short
State is a
cannot be-
contestant respondent.
29.
My lord.
Seal number
this-
29.
My lord, this pertains to construction of a cancer hospital, my lord. If my lord could have it.
It is also PIL.
No,
No, my
lord,
lords.
this is an appeal, writ appeal.
It was heard once.
Yes.
Please, my lords. Since my lords are also short of time today, my lords, 11.
May I
No,
submit?
no, we are full of time. You are short of time because you
My
are.
lords, may I submit? I have
That's
filed-
also frankly.
I have filed the impleading application. We are the affected party.
So I'm requesting for 1 week next week, my lords, any date.
18th.
18 minutes.
18th. But on that day we'll proceed.
Please, my lords. My lords, there is an undertaking given by state that may be extended till next date of hearing.
Undertaking shall continue. Undertaking recorded as above.
My lords, at the
Recorded
same time,
earlier shall continue to.
my lord, my application may be allowed, my lord. I have filed the impleading application.
Which one? What?
Impleading in the same matter, my lord,
On that day.
please.
Kindly, my lords, seal number 33, lords, contempt. Lord, it is posted, my lords, as my lord, the response is not filed. My lord, in fact, my lords, I am issued with an endorsement. Prima facie, my lords, bare reading, my lords, is in violation of the order of the learned single judge. My lords, as such, I have filed a rejoinder. But your lordship may have it, my lords, any short date, my lords,
It
so
is
that
already kept. When do you want?
any day, my lords, I am ready.
Tell the date and keep.
My lords, Monday or Tuesday, my lords,
Monday, 9th.
obliged,
9th of September.
obliged.
As requested by learned advocate, stand over to 9th.
But if my lord may just see the list of dates that I just passed on, notes. List of dates. My lords, 27/5/1989. Lords, respondent herein was appointed as first division assistant by the management of a aided high school. Then on 28/12/89, my lords, the appointment of respondent was approved by the state government without salary grant. Then, my lords, on 9/6/99, which on the basis of which, my lords, they are placing reliance, a government order was issued according approval for admission into salary grants in respect of 1,116 posts comprising of 323 non-teaching posts covered under government order dated so and so, and 490 non-teaching posts appointed as per rules between 1/9/1990 to 1/3/1992, and in the said order, only 8 plus 3 posts of FDA in composite pre-university colleges have been accorded sanction for admission to salary grants. Then, my lords, on 22/11/2004, the respondent admitted to salary grant with and condition number 2 specifically provides that the salary grant is only from the date of the said order, which is as per rules, my lords, and the service rendered during the non-grant period, no grant period cannot be considered for the purpose of giving of the salary. 10/10/2005 request for the by the respondent for admission to salary grant with effect from so and so was rejected by way of endorsement, my lords. Then on 9/7/2008, WP number 3521 was filed by the respondent, was allowed in part, and an endorsement dated 10/10/2005 was quashed, and matter was remitted for reconsideration, specifically stating that reconsideration shall be in accordance with law and after collecting necessary materials from the institution where the respondent was working, with permission to submit additional representation to substantiate the claim for the said benefit from 9/6/99 and not from 22/11/2004. Then, my lords, he gives a representation on 29/12/2011, submitted seeking for extending the benefit of salary grant from 99 till 2004. On 2/4/2012, my lords, WP number 8285 of 2012. Then, my lords, WP number 8285 2012 was disposed of with a direction to consider the representation.
Additional, what prompt, you have produced some order.
Please, my lords. Lords,
So what prompted the authority to pass this order?
which order, my lords, with regard to
Today,
taking
which is produced.
my lords, this order, my lords, was passed. My lords, under the rules, if a person is admitted to salary grant from a particular day, my lords, they're all not our employees. They're employees of a aided school, my lords.
Which authority passed the earlier order which is withdrawn?
Please, my lords. My lords, the earlier order that was passed,
The order which is withdrawn by this order was passed by which authority?
please, my lords.
Same additional commissioner? Have you got that order?
Please, my lords, I'm just pointing out, my lords. Who
Same
passed? I'm just pointing.
Additional Commissioner, School Education Department, Kalburgi passed the earlier order.
Please, my lords.
And the same authority is withdrawing it.
Please,
How
my
can it be done? He is punctuous official.
No, my lords, under 21 of the, no, my lords, kindly note this fact.
We are taking on record, but we'll consider what.
Please, my lords, my lords,
What significance can be attached to this?
please, my lords, my only thing is on the basis of a rule position. My lords, my lord, we are not litigating, my lords, as against my lords, aided school teacher. The state is not litigating, my lords, only for the purpose of litigation. It is about, my lords, public money being, my lords, spent on, my lords, for the purpose of salary grant. They were appointed, my lords, as private school teachers in an aided school. After 10 years, my lords, they get admitted to salary grant in 2004. His case is, from that day, my lords, he is entitled to salary grant. That is a rule position. His case is that from 5 years prior to that, please fix my salary grant from that date, give me the benefits. That is all his case is. In the first round of litigation, my lords, 3 people came before this honorable court, including the respondent herein. This honorable court, my lords, considered and asked us to consider in accordance with law. An endorsement was issued to them, all of them, that you will not be entitled to. And direction was issued to consider in accordance with law. That is all the direction. I will in fact read that. Lords, at that point in time, in respect of 2 persons, my lords, it was a separate division, a Kalburgi division. The other division, my lords, belonged to Bangalore division. So insofar as Bangalore division, my lords, as per rules, my lords, there was a rejection of the petitioner's case. Then, my lords, he approached this honorable court again. Then therefore, afterwards he approached, my lords, the appellate authority. Appellate authority rejected his request. Second appeal was filed. Second appeal is rejected. Thereafter, my lords, he files a revision. Revision is allowed, which is by the government. Then a review petition, my lords, by the government against the revision again is allowed, my lords. Thereafter, he approaches this honorable court again. This honorable court sets aside the order of the revisional authority, review order, remands the matter again. Then, my lords, again, my lords, we have considered in terms of rules and said it is not permissible. Then again, my lords, now the learned single judge finding is, now I'll just point out the rule. If rule, according to rule is entitled, he is entitled. It's not about, my lords, one person. If suppose it is about, my lords, why the state, my lords, litigates in these matters with regard to public monies is that suppose, my lords, there will be thousands of aided employees across the state. If it is in respect of one person, now in respect of 2 people, they're seeking for palliative. Only on that ground, my lords, his claim has been allowed, my lords, even by the learned single judge, even by the revisional authority. Now, my lords, only on the ground of, by mistake, my lords, some benefit has been granted. Public money has to be paid to him. And therefore, my lords, our concern is that even in respect, wherever, my lords, rule position does not allow me, I will just point out the rule, my lords, and I will close my case. May I just point out the rules, my lords, in this regard? In this, rule 3, rule 3B, my lords. I'll just read, my lords, Rule 3B. Subject to the financial capacity of the state government, the salary of the employees in respect of posts admitted into aid in recognized private educational institutions receiving aid from the state government shall generally be the same as those applicable for the corresponding category of employees in government educational institutions as per orders issued by the state government in respect of this category employees from time to time. Now kindly see, my lords, provided that no employee of an aided institution shall be entitled to the benefits enumerated in Annexure 2. Now, my lords, kindly see Annexure 2, my lords, of this rule. At the end, my lords, from the end, my lords, 5 pages from the end. My lords, get Annexure 2, my lords. List of benefits not admissible in respect of employees of aided institutions. Please. Annexure 2, my lords. List of benefits not admissible in respect of employees of aided institutions. Benefits not available for service rendered during unaided period for the purpose of fixation of pay, leave, pension, or any other service benefits by the government. So therefore, my lords, he was admitted to salary grant in 2004. From that time, my lords, state government has paid its salary through the management, and my lords, now he is superannuated. Whatever benefits, my lords, under the triple benefit scheme, he is entitled to. There is no dispute about it. His entire case is that if you take my case from instead of 2004 from 1999, 5 years he will get revision, and consequently his pay will get revised and his pension will get revised and all these things, my lords. Therefore, that is where he is coming from. My lords, we have not accorded this benefit to anybody across the state. In respect of in this matter, in respect of 2 out of 3 employees, my lords, by oversight, my lords, 2 employees were granted that benefit. And my lords, today, after having realized, my lords, that it is contrary to the rules, and that and the learned single judge as well as the appeal order that is referred to in the appeal by the learned single judge, both, my lords, are only on the ground of parity, except that you have given it to 2 people. There is no adjudication that he is entitled from 99. If there is an adjudication, my lords, by any authority that on the basis of his service conditions, on the basis of the rule position, he is entitled to from 1999. That has never been adjudicated, my lords, is my respectful submission. Learned single judge has relied upon, my lords, order at page 100. But in page 100, my lords, there has been no adjudication. Learned single judge has actually remitted the matter for fresh consideration. And with, kindly see, my lords, for a moment, I'll just read that order, my lords, at page 100. My lords, 104 is paragraph number 4. They are relying upon para 4. I'll just read from para 4, my lords. My lords, get it, my lords, page 104. After careful perusal of the materials available on record, what it emerges is, in fact, the government has approved the grant in respect of 1,116 non-teaching staff appointed between 1/9/1990 to 1/6/1992, and the appointment of these petitioners would also to fall within the said period. Therefore, the authority ought to have called for the report from the schools, colleges where these petitioners are working, but inadvertently or oversight, their names have not been included for extending the benefit of the government order dated 9/6/99 for no fault of them. And when the approval has been accorded by the government, it ought to have been called for details from the person who have not been extended the benefit, and contrary, as per the representation dated 6/8/2005, first respondent issued the impugned communication dated so and so, stating that these petitioners are entitled for grant from 21/11/2004 and not from 9/6/1999 without any justification or without assigning any reasons. Nor there is any reference regarding the thorough verification of the particulars of these petitioners as to whether they're entitled for extending the said benefit, and unilaterally first respondent has taken a decision and issued the impugned endorsement stating that they're not entitled for grant without assigning any reasons. Therefore, the impugned communication issued by the first respondent dated so and so via annexure A cannot be sustained, and it is liable to be set aside at the threshold. In the lights of the facts and circumstances of the case as stated above, the writ petition filed by the petitioners is allowed in part. The impugned communication dated 10th October 2005 issued by the first respondent bearing number so and so via annexure A is hereby set aside. Kindly see this, minutes. Matter stands remitted back to the jurisdictional competent authority of the respondents for reconsideration of the request of the petitioners and to take appropriate decision in accordance with law, after affording reasonable opportunity to the petitioners and after collecting necessary details from the institutions where the petitioners are working, and dispose of the same as expeditious as possible, at any rate within a period of 4 months from the date of the receipt of a copy of this order. Further, petitioners herein are permitted to submit their detailed consolidated representations along with necessary notifications, orders, or other materials to substantiate their claim that they're entitled for the said benefit from 1999 and not from 2004. After this, my lords, we have considered, issued an endorsement that you are not entitled. It's a detailed endorsement. That has been upheld, my lords, in the first appeal, second appeal. In the revision, it was set aside, but again, review, my lords, it has been upheld. So there, finally, my lords, when this honorable court, my lords, has now granted relief in the impugned order, if my lords may kindly see at page number 38, impugned order starts, my lords, at 34. At 38, para 5, I will read, my lords. In the para 5, my lords, at page 38. In the light of the submissions made by the learned counsel appearing for the parties, on careful examination of the GO dated so-and-so, the government has taken a decision to dispense with economic measures and such approved nearly 1,116 employees in the state, and the same is subject to the terms and conditions referred to in GO dated so-and-so. The only compliance to be made by the applicants is seeking benefit of the GO dated 9/6/1999, that their name should be in the staffing pattern prior to 1/3/1992. It is a case of the petitioners that the petitioner was working as FDA accountant at so-and-so since 27/5/89, and therefore the appellate authority has rightly passed order stating that the petitioner is entitled for benefit from 9/6/99 and not from 22/11/2004. This aspect of the matter was also considered by this court in WP number so-and-so, disposed of on 9/7/2008, wherein the petitioner has been arraigned as petition number 3 in the said petition. The state government has extended the benefit from 9/6/99 to 2 petitioners in the above writ petition in terms of the order dated 15/6/2009. However, the case of the petitioner was not considered. In that view of the matter, the reasons assigned by the revisional authority as at Annexure T is arbitrary, and the order passed by the appellate authority, whereby appellate authority has rightly come to the conclusion that the petitioner was working in the college prior to 9/6/99, and as such it has been held that the case of the petitioner has to be considered in the light of the GO dated so-and-so, and in that view of the matter, I pass the following order. Notes, my submission is this. Single judge, my lords, has not decided the eligibility of the petitioners. In the appeal order, if my lords may kindly see the order in appeal, my lords, it is only on the ground of parity. I'll just show that paragraph, my lords. Page 179. At page 190, my lords. Top of the page. Page 179 at page 190, top of the page. Already the deputy director to Sri Arvind so-and-so and Haji Begum to grant salary from the period from 99 to 2004 has passed this order. And as per the said order, to me too, it is requested before his authority for the salary from so-and-so. With regard to this appeal, the petitioner and the respondents issued documents are examined. The arguments heard, observed, and order is given. The appeal filed by so-and-so is allowed. And my lords, this order has been set aside, my lords, in a review, which has again, my lords, been set aside, my lords, by this honorable court and matter remanded.
Which order is set aside in review?
My lords, the order at page 179. That was set aside at page 211.
This order was sought to be reviewed by the very government itself.
Power is there.
Order is passed by the government, and subordinate officers files a review petition, the very same appeal order, and they managed to get this order reviewed and get the sorted order
He has
set
filed,
aside.
he has filed 2 appeals under section 130.
Yes, what is the personal
And
interest of
131
the-
and 133. Page 211, my lords, is the order setting aside the order in appeal. And this order at page 211 was set aside by this honorable court, matter remanded back. Again, my lords, there is a fresh order, which again setting aside the same order at 232. In my list of dates, I have given that, my lords. Lords, may I just make the submission? Lords, his entitlement has to be decided, which has not been decided, my lords, by the learned single judge. In terms of the rules.
You are in a non-teaching spot, non-teaching.
Accountant.
Account.
First division.
Page 94 is the impugned order. It was upheld by Learned Single J. 94.
No, it's 94 is his appointment from 2004. No dispute about that. 94 is his appointment order admitting to salary grant from 2004. Condition number 2 says from that date it is applicable.
Which is order dated 22/4/15.
179.
170.
This order was set aside in a review. Single judge sets aside the order in review petition and upholds this order. But only on parity.
May I make some?
That order was set aside at 232. That appellate order was set
May I-
aside at 232.
May I make?
Single judge sets aside 232 order, my lords, and upholds the appeal order. My
Lords.
submission, my lords, is only this, that on merits, there has been no consideration.
This,
And rule has not
Lord,
been
Mr.
considered. my lords.
And this, all this 800. The
May I make submission? Lords, may I make? This rule which is relied upon by the government is not applicable to the case of the petitioner for a simple reason. I am not seeking, my lord, the salary of the unaided period at all, my lord. If the case of the government would have been correct, if I would have sought arrears of salary from the date of 28/12/1989. Therefore, this rule is applicable to only those employees who seek, my lord, the arrears of salary with the date of approval. My lord, the government, that is cabinet, on 9/6/99, considering the, my lord, grievance of the unaided staff, my lord, took a policy decision to admit, my lord, unaided staff for a grant in aid. My lord, the case of the petitioner is that I am eligible for the grant from 9/6/1999, under which the cabinet has took a policy decision at page number, my lord, 80. It is a cabinet decision. It is a policy decision. It is passed in the name of the governor. My lord, the cabinet grants, my lord, facility to the unaided staff to, my lord, grant. the commissioner inadvertently, my lord, consider case of the petitioner and grants a benefit from 22/11/2004. My grievance is when the cabinet takes a policy decision, this honorable court clearly held the authorities ought to have considered the case of the petitioner with effect from 9/6/1999. I'm not, my lords, claiming arrears from 1989. I'm claiming arrears with effect from 9/6, government order dated 9/6/1999. Page number 80. My lord, cabinet facilitates the non-teaching staff for grant. Everyone has been given grant with effect from 9/6/1999 except the petitioner. Except the petitioner. So here the issue before this court is only this. My lords, my lord, issue. Lords, my lord, issue before my lords is only this. Whether the petitioner is eligible for grant with effect from 9/6/1999.
Bill 91 of 2024. Third learned Additional Advocate General, Mr. So-and-so, assisted by learned Additional Government Advocate, Srimati Nilofar Akbar for the appellant state, and learned Advocate, Mr. So-and-so for the respondent, original petitioner. Respondent dash original petitioner. The challenge in this appeal required under Section 4 of the Karnataka High Court Act 1961, at the instance of state, is addressed to judgment and order dated 12th June 23 of honored single judge, whereby the honored single judge allowed the writ petition. Post of order dated 29/5/19 passed in review petition number 147 of 2014 came to be set aside, whereas order dated 22/4/2015 in appeal number 147 of 14 passed by the Deputy Secretary to Government, Integrated Services, Primary and Secondary Education Department, Government of Karnataka, Bengaluru, came to be confirmed. The issue involved in the controversy is about the granting of benefit of allowing the benefit of grant towards salary to the petitioner during the period from 9/6/1999 to 22/11/2004. The order of the competent authority dated 22/4/15 upheld by learned single judge directed to consider the appointment of the petitioner with salary grant from 9/6/1999 to accord such benefit for the period from 9/6/1999 to 21/11/2004. The claim of the petitioner that he was entitled to such benefit from 9/6/99 in respect of his services and not from 22/11/2004 was accepted. Paragraph noticing the basic facts, the original petitioner respondent herein was appointed as first divisional assistant on 27/5/89 in one Milak MIAATH Educational and Welfare Society, Davangare. The appointment of the petitioner came to be approved by the government as per order dated 28/2/1989. But it was without salary grant. It appears that the state government subsequently passed an order dated 9/6/99 whereby 1116 number of non-teaching staffs, 1116 number of non-teaching staff were admitted for salary grant. Full stop. The petitioner was not given the benefit from the said date, namely 9/6/99, but was considered for such grant, but his case was considered for such grant with effect from 22/11/2004. Paragraph. The petitioner, the original petitioner, the petitioner respondent herein had an occasion to file writ petition number 3521/2006 seeking declaration that the respondents were liable to extend the benefit of grant to the petitioners, including the present petitioner, with effect from 9/6/1999. And the action in not extending such benefit from the said date was arbitrary and illegal. The said petition was disposed of by order dated 9th July 2008 by this court. The petitioners, whom included the present one, were permitted to submit detailed representation to the competent authority to seek entitlement for the benefit, to seek the entitlement for the salary grant benefit for the said period from 9/6/99 to 22/11/2006. Paragraph. Noticeably, while remitting the case as above to the competent authority, this court made following observations, extracting paragraph 4 from the said order dated 9/7/2008, page 104, paragraph 4. It starts from after careful perusal of the material. Without justification or without assigning reason, that is how it ends. The court proceeded to observe that The denial of the benefit was without any reference to the particulars, and it was not known as to why the petitioners were considered to be not entitled for extension of the benefit. Consequently, with such reasoning, the impugned communication reflecting the decision of denial of the benefit dated 10/10/2005 was set aside and the case was remanded. Since the claim of the petitioner again met with the same fate, the cause of action arose to file another petition which culminated into the order as above, now under consideration in this writ appeal. It is to be noted, paragraph, as is reflected in the order, which was perhaps the order passed by the Additional Secretary to the government in first point of time on 4/11/2004, which considered the question of extension of benefit from 9/6/99. It was recorded that the case was considered for those employees who were appointed during the period from 1/1/1990 to 1/6/1992, but were ineligible to receive the grant, as also few of the non-teaching staff employees who were left out of the order dated 9/6/1999. In other words, the petitioner fell in the category of the employees left out from being extended the benefit as per order dated 9/6/1999 to be considered for the salary grant from the said date. Paragraph. The facts stare, paragraph, the facts stare at the face that as many as 1116 non-teaching staff appointed between 1/1/1990 to 1/6/1992 were accorded the benefit accorded the benefit of salary grant from 9/6/1999. Admittedly, the petitioner's appointment, date of the appointment of the petitioner's date of the appointment of the petitioner, including the other two petitioners who filed the previous writ petition number 3521 of 2006, held within the said period between 1/1/1990 to 1/6/1992. No reason forthcame as to why the petitioner was left out from extending the benefit. The conspicuous aspect is that the other two petitions, along with whom the petitioner had filed the said earlier petition came to be granted the benefit to the exclusion of the petitioner, for which also no tenable ground is forthcoming. Law on a single judge paragraph. While allowing the instant writ petition, recorded his findings thus in paragraph 5 of the order. Then quote, ... the inward comma, on careful consideration of. Up to said writ petition. Paragraph, learned single judge paragraph noticed to observe that the state government has extended the benefit from 19196/1999 to the other two petitioners in the said petition, and that the case of the petitioner was not considered. Learned single judge therefore viewed that the reasons assigned by the Revisional Authority in negativing the claim of the petitioner were not sustainable, whereas the Appellate Authority was justified in coming to conclusion that the petitioner had worked in the college prior to 9/6/1999, and there was no good reason to deny the salary grant benefit to the petitioner from the said date. Full stop. Learned single judge therefore directed that the case of the petitioner has to be considered in light of government order dated 9/6/1999 and passed the operative order. This court is in agreement with the reasonings applied by learned single judge to affirm and uphold order dated 22/4/15 passed by the competent authority in appeal. Learned Additional Advocate General for the appellant state sought to rely on Rule 3B of the Karnataka Educational Institutions into bracket recruitment and terms and conditions of service of employees in private aided primary and secondary education institutions, bracket over Rules 1999, and the proviso thereto, comma, to submit that the petitioner cannot be extended the benefit as above. Learned advocate for the respondent petitioner would submit that the said rule would not apply.
Not apply because I'm not claiming arrears from 1989. I'm only claiming arrears from 9/6/19. It is applicable to
Inasmuch as the claim of the petitioner is only from 9/6/1999 and not from the date of original appointment.
Yes, my lord.
Full stop. The court finds substance in what is submitted by learned advocate for the respondent petitioner. Paragraph. In course of hearing today, on behalf of the appellant, a memo was, what is this memo? A memo was filed in which, along with which, order of the Additional Commissioner, School Education Department, Kalburgi, dated, what is the date?
17/8/24.
17/8/24 was produced, on the basis of which learned additional advocate general submitted that in respect to the two other employees who are the co-petitioners along with the petitioner in the previous writ petition number 3581 of 2000, whatever. The benefit has been withdrawn. Full stop. When the court put a query as to under which provision and under which circumstances the aforesaid order was passed, aforesaid order came to be passed, learned additional advocate general was entirely at his receiving end.
We are relying,
Full
general
stop.
clauses act, that's what I said.
Not only that, it was admitted that the order of withdrawal was passed by the very authority which had passed the earlier order. Full stop. In this regard, it was submitted on behalf of the petitioner that the authority had become functus officio and order of withdrawal could not have been passed, could not have been competently passed, could not have been passed by him. Full stop. This submission could not be brushed aside lightly. Not be as it may. Full stop. Even otherwise, when we look at the order, the order provides that there shall be no recovery, that
Last but one line of the order.
recovery shall not be effected
Yes,
from the
there is
said
no recovery at
petitioners.
all.
Paragraph. The court does not find any good reason to advert to for any purpose whatsoever the said order dated 17/8/24 produced today, inasmuch as in the facts of the case, this court is in entirely agreement with the reasoning supplied by learned single judge in allowing the petition of the petitioner to extend the benefit of salary grant from 9/6/1999 to whatever date, 22/11/2004. The judgment and order of learned single judge does not call for any interference, does not book any error, and does not call for an interference in the appellate jurisdiction. The appeal is dismissed.
Time for compliance has to be extended. Single judge are granted 8 weeks to comply. We need time for compliance of the orders.
At this stage, learned additional record general fairly stated.
Only one submission, then Your Lordship, I leave it.
Time may be granted.
Lord,
to
22/8/23 is the date
comply
expired.
with the order.
It is
Comply
1 year,
with-
exactly 1 year back.
6 weeks time is granted to
Please.
comply with the order, within which the benefits shall be accorded to the petitioner.
This matter may kindly be called, contempt matter may be called all after 6 weeks.
Contempt matter will not survive.
Please.
In view of the order passed
Lord,
in the writ
Liberty
appeal
to, my Lord,
and the extension of time given to comply with the order as per the request of learned additional advocate general, the contempt proceedings will not survive and they are accordingly, full stop, they are accordingly disposed.
Lord, liberty reserved to revive the contempt in case of non-compliance. Lord,
Always.
otherwise, let them file affidavit. My Lord.
It is always,
My Lord, I have come across.
we are directing them, what if
Lord,
we are
contempt-
directing to comply with,
Lord, if they don't comply, any interest.
then contempt will lie.
Lord,
Everything not to be stated in your,
my Lord, otherwise my contempt.
you can file contempt, if not. Yes, next.
Grateful.
Cell number 106.
Right, ma'am.
Which matter is to be?
Government seats, my lords, under sports quota, which, my lords, I argued, my lords, the state raised two objections, saying that I was not part of.
What is this is that the certificate of produced before the authority.
Yes, that I have already produced the certificate.
What happened?
He filed some rejoinder, my lord. Then lordship wanted us to any response. As far as I am concerned, I have no my lord, response to
We have
this.
filed
Government-
respondents, ma'am. We have filed our statement of objection.
Virtually it
Eligible?
supplants, my lord, the,
Lord, the,
Eligible or not?
no.
Lord, the two contentions which were taken by the state was one, my lords, I was not.
Take up on Monday or.
Tuesday, lordship.
Tuesday.
Lord, the only difficulty would be, my lords, if they start filling up of the seats. I don't know, I'm not sure, my lords, when the counseling, my lords, is going to be.
No,
my
of
lords.
course, only after 12th, my lord. Only after 12th.
Tuesday.
You want early, we can keep it day after tomorrow, subject to.
But
your-
I am
Day after tomorrow, I have some difficulty. I have some-
Tuesday, ma'am.
Tuesday.
published.
Lordship's kind permission, my lord. Serial number 105, my lord. I wanted to report compliance of the order of the learned single judge. Today it was listed, my lord, specifically at 2:30 under the caption of orders. I may be permitted to place on record the compliance affidavit, compliance memo.
Learned Advocate files compliance memo, which is taken on record.
My lord, one submission, my lord. Madam, what happened?